Welcome to Immigration Insider with your host, attorney John Nicelli. This podcast is an educational forum on how to deal with complex aspects of immigration and pitfalls to avoid. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, johnnicelli.com. Now here's the host of Immigration Insider, attorney John Nicelli.
Hi, everyone. I'm John Nicelli. I'm an immigration lawyer practicing for over 42 years, exclusively in the field of immigration law. And today on this podcast, we're going to be talking about something called a labor certification, meaning being sponsored through a job, commonly known as PERM. Originally, it was known as just a regular labor certification application. And then a few years ago, the government decided to change things, and they name it now PERM, PERM. So I'm going to tell you each process of how labor certification is filed and what the requirements are for the position. So first of all, the first thing everyone should know is that in order to be sponsored through a job, you are not required to work for that employer until you actually receive your residence. So when you receive that green card, then and only then are you required under the law to actually start working for the employer. Now, what does sponsorship means? Sponsorship means that an employer has a business here in the United States, or could even be a family if it's for like a domestic worker, and they need someone to provide a specific skill in their business or household. So in a household, it could be a nanny, it can be a household, it could be a butler, it can be any kind of a home attendant, generally, any skilled worker for a household. And for an employer, for a business, it can be basically almost any job you can possibly think of. So skilled worker means you have a special skill that an employer needs here in the United States. So the way it works is this. The first process would be you have to find an employer. So let's say you find an employer to do whatever it is you hope to do in the future. So that employer must first engage the attorney, obviously, and they have to do what they call a prevailing wage request. Prevailing wage request means that the employer notifies the United States Department of Labor, submits a form to them, and describes to the Department of Labor what that job duty entails. The Department of Labor in turn will do their research on that particular position, and they will come back some weeks later, sometimes months later, and they will tell you what the going rate is for that position. So if the position involves a wage of say $20 an hour, so $20 an hour is $800 a week. That means that employer must have the ability to pay the wage. So when we start a case, we usually check the employer's taxes to verify that the employer has enough net income to pay that wage. Now, if you're on the employer's payroll already, since many people are, and they are paying the wage, then there's no issue about their ability to pay the wage. But if they're paying less than what the Department of Labor considers the prevailing wage, then you must verify that on the taxes that the employer has sufficient net income to pay that particular wage. So prevailing wages are valid for generally no more than 1 year, but they have to be valid for at least 90 days, but no more than 1 year. Now, the Department of Labor uses many criteria to determine what a wage is. It's the type of skill that's involved, the dangers involved, the education involved for that position, many factors. And then they come up with a wage, and then basically you're stuck with that wage to advertise for the position that's being offered. Now, when I say advertise, there's a particular way of doing things that must be done in this manner as the Department of Labor dictates. So first of all, once the prevailing wage is accepted and the job duties accepted, then you have to do recruitment. Recruitment is basically requires a newspaper ad put in generally on a Sunday in 2 newspapers of general circulation. So if you live in a city, it's basically the largest, generally the largest newspaper in the city, because that would get the most responses. If you live in a small town, then whatever newspaper you have in that small town. So some jobs, depending on the skill on the job being offered, also require a job to be offered in a professional trade journal. Now, those jobs are for professional jobs. For example, you may have a particular type, a scientist, for example, that would require a job offer, not only a job ad, not only in newspapers of general circulation, but in a trade journal as well. And that would depend on what the skill is, and that will determine if a professional trade journal would be necessary. And the ad must also be placed in the state workforce agency. The state workforce agency is basically the unemployment office. So you have to advertise that job with the state. They post it on their website that you as an employer have this job available. So if anyone responds to that website, then the employer is required to review the resume, and if they appear qualified, they must interview that individual. The same applies if anyone responds to the newspaper ad. So if someone appears qualified, they have 10 years experience for a position you're only requiring 2, you will be required to interview that person, and you must find a job-related reason why that person is not qualified for the job. If the person is qualified for the job, the Department of Labor will require you to hire the person, and they will never approve the labor certification for the foreign national. But there's many ways of getting around that, because many times I've had employers who have a job available and they advertise the job, someone answers the ad, and they say, wow, I like your skills, but I'm not going to hire you for that position, but I'm going to hire you for another position I have also available. And if they do that, then the labor certification would be approved. There should be no problem. Once the advertising is done, then you're required to file. To file with the U.S. Department of Labor, everything is electronic for the most part. You can mail it in, but it's probably wiser to do electronically. The problem with doing it electronically is that when they changed the system a few years ago, if you make a simple mistake on an application as it's typed and then submitted electronically, that simple typo can result in the case being denied. So that's the downside of filing electronically, because sometimes people make simple mistakes, and sometimes you can explain it to the Department of Labor as just a simple error, but they may or may not accept your reply. Now, if someone answers the ad, and let's say you reject 2 or 3 people for that position, the Department of Labor reviews the resume, and if they feel that that person was wrongfully rejected, or more than one person was wrongfully rejected for the position, then the Department of Labor is going to do what they call an audit. Now, when they do an audit, they're going to go over every step of the process that you took. They'll check from the prevailing wage that it was done correctly. They'll check the advertising in the newspapers if it was done correctly. And they'll check your reasons for rejection. And they usually will want further explanation as to why a person who appears qualified was rejected for the position. Now, if you can't find the reason other than the ones you stated, more than likely it will be denied. So generally, you have to review the resume again and then find a job-related reason why the person does not qualify, besides the reason that you already mentioned. And then once that is done, you'll be required to, once the case is approved, then you'll, at that point, the document is certified, and then within 180 days, it must be filed with the immigration services. So U.S. Immigration, U.S. Citizenship and Immigration Services. Now, USCIS. So once that's done, there's a form called an I-140, which has to be filed. When at the I-140 stage, you have to submit the person's basic documents and the employer's verification of their ability to pay the wage. So ability to pay the wage is done generally through tax returns. It could be done through a 1099. It could be done if it's paid to the employee, and it could be done through a W-2 paid to that employee. If they're not on the payroll, then you must document the tax returns are sufficient. If the employer is a large company, they have over 100 employees, generally the CEO or the financial director of the company could write a letter state that we make this amount of income, we have sufficient income, we have over 100 employees employed, and then they will waive the requirement, generally waive the requirements for submitting tax returns. Once the I-140 is approved, then the next stage would be to file for adjustment of status. So if the person is lawfully in the United States, then you would file adjustment of status with the U.S. Citizenship and Immigration Services, and that process takes probably about another year. But during the time you're waiting for it to be processed, that individual will receive their permission to work and generally will receive their permission to travel. If the person is unlawfully in the United States, depending on how much time unlawfully they've spent here, they would be required to go overseas. Their documents are sent to the National Visa Center. If a document is sent to the National Visa Center, it's then processed. They prepare all the documents needed, birth certificates, marriage certificates. They review the documents, divorce decrees, for example, death of a spouse or a child, whatever it may be. And once they okay all the documents, then it goes to the American Consulate or Embassy abroad. Now, if you've been unlawfully in the United States and you are living illegally in the United States for more than 6 months, that would require that you have to file a waiver because you have to be forgiven for your unlawful presence. If you are here more than 1 year, you have a 10-year bar. So you would have a big problem. If you're here 6 months, it's only a 3-year bar. If you're here 1 year illegally, it's a 10-year bar. In order to get a waiver, you have to have a parent or a spouse who's a resident or citizen of the United States. So if you're here illegally for more than 1 year or more than 6 months, and you don't have a family member that's a spouse or a parent that's a resident or citizen, it would be a total waste of time to be sponsored through a job, because at the end, you will be required to file a waiver and you will not get your residence. The other option is to wait in whatever country you're from for the period of 3 years, and then you would not need the waiver to come back. Or if you have the 10-year bar, you'd have to wait that 10 years. And the labor certification, everything would still be valid. But at that point, what will happen is the consulate will say, hey, wait a minute, this employer needed you 3 years ago or 4 years ago or 10 years ago, and please prove to us that they are still in need of your services now. That could be problematic, but of course, we'd have to see what the situation is. The employment-based cases are broken down into preference categories, basically, with immigration. And the preferences are the first preference to the fifth preference. So in the first preference case, that would be a person of extraordinary ability. And that type of person of extraordinary ability would be a person that has accomplished so much in their life that a labor certification is absolutely not necessary. For example, if you have a person like Jeff Bezos, for example, who started Amazon, he's a person that would be considered of extraordinary ability because he started from nothing and built this multi-trillion-dollar company. So that's what they would consider a person of extraordinary ability. Or you could be an outstanding scientist. Suppose you won the Nobel Prize, and you could win the Nobel Prize in science or in literature or something else. You would be outstanding. Perhaps you're a movie director, and you've made some of the best movies ever produced, and those movies have won all kinds of awards. You might qualify for extraordinary ability petition, and then, of course, you would be approved, and you'd be able to get your residence. The second category would be persons of, how would I say it, that have very, 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 very good education, a lot of experience in their profession, but they would require a labor certification. And those people are a little less than considered a little less than extraordinary ability. And for example, let's say you're a CEO of Home Depot or Target, and you were an immigrant and you started this huge business. Probably you'd have what they call you'll be a multinational executive. You would consider that your accomplishments are so wonderful, but they don't rise to the level of extraordinary ability because perhaps you don't have the education, but you have the work experience. So there's also third preference. Third preference would be most people who are getting their residence through employment. The employment would be basically any job that I described previously. There's also what you call fourth preference. Fourth preference is generally for religious workers. It's reserved for special immigrants like juveniles who are wards of a state. And it could be employees of retired employees of international organizations. So, for example, suppose you worked for the UN for many years, you held high positions in the United Nations representing your country, you would be eligible for what they call an EB-4 visa based on your expertise for that organization. And then the fifth and last preference, employment base, is generally making an investment in the United States. That's a little more complicated. It would be for another podcast. But basically, you'd have to invest at least $1.8 million in an investment in the United States. And that investment would have to potentially employ a minimum of 10 U.S. citizens or permanent residents or people who are authorized here to be here. Or you can invest $900,000, which would be an investment in what they call targeted employment. So that would be a specific area that immigration approves for the investment. So generally, it's in an area that's not as populated as the big cities, and there may be underemployment in that area, and there may be many other issues there. As I said, that's for another podcast day, which is very detailed because the investments are very tricky. That's basically it for employment-based visas. If you have an employer that's willing to help you, you can explain what the requirements are. You can have them call me. You can make an appointment to see me. We'll break it down. If it's possible, we'll do it. If it's not possible, we're not going to waste your time or their time. Another requirement is that the employer is required to pay the attorney, whatever the attorney fees are, and the advertisement costs whenever the case is filed. So it's very important to know as well. And under the law, there's no reimbursement to the person who's being sponsored. All right, so thank you very much for your time, and I hope you learned something today about employment-based immigration. Thank you.
You've been tuning into Immigration Insider with your host, attorney John Nicelli. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, johnnicelli.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.